Okay, so we have gone over, what can be covered under copyright law. Now we need to take a look at the things that are not covered under copyright law. So, since it doesn't cover everything, it doesn't cover facts and ideas, system methods or discovery, um, public domains works, and functional elements. So, we'll take a look at each of those and kind of do a quick discussion on them. So, facts and ideas. So, copyright law does not protect facts or ideas. It only covers the original expression of ideas or the specific way which facts are presented. The underlying concept or truth itself is free for everyone to use. So, here's a couple of examples. The fact that water boils at 100 degrees Celsius cannot be copyrighted. Anyone can state that fact in a research paper, book, or article. Historical events, for example, the Battle of Gettysburg is a historical fact and it cannot be copyrighted. However, the expression of that event in a historical book or a film can be copyrighted. Ideas. So let's say you have the idea for a superhero who fights crime. That cannot be copyrighted. However, a specific character created with original traits, such as Batman, can be copyrightable. So there's a distinction between a high-level idea and its expression. That distinction is critical to determining whether or not the work is covered by copyright law or whether it isn't. So the idea itself is basically free for anyone to use, but the specific expression of that idea, such as in a form of a book or artwork or a film, can be protected. Let's take, for example, the idea of a dystopian future. Is a very common thread, and it is unprotected. Anybody can write a story about a dystopian future. But George Orwell's specific expression of that idea in his novel, 1984, that is copywritten. That was his idea. That was his vision, if you will. And you can have that vision, but unless you put it on the paper, you're not going to get, it's not going to be copywritten. Systems, methods, or discoveries are excluded from copyright protection. Some of them may be able to be covered with a patent, but it just depends. So, for example, mathematical formulas, like let's take the Pythagorean theorem that explains the relationship between the sides in a right triangle, cannot be copywritten. Recipes, while the specific language of the recipe can be copywritten, the method of preparing the dish cannot. For example, let's say I write a recipe for lasagna. It can be protected, but anyone is free to cook lasagna however they want to, their own way. Programming language. So, programming language like Python or Java is a system for writing code. The language itself cannot be copywritten. However, the way in which you put together and write individual programs, that language can be copywritten. Think of it as if you have an idea for a book, right? You write that idea down, you make a book, it's fixed in a tangible medium. It's just, I write it in English, right? Well, what if I decided to write it in Python or Java? That's kind of what coding is. So it's the way in which you put it together that makes it protected, not the language itself. So you can't copyright the English language, therefore you cannot copyright Python or Java. So that's the best way I can think to explain that one. So public domain, we talked about, when copyrights expire, things enter to public domain. Or maybe that work was never eligible for a copyright, and so it's just out there for everyone to use. And maybe the author decided, hey, I want everybody to use this, and just put it out there in public domain, and therefore anybody can use it. So a lot of classic literature. So works like Shakespeare's plays, Pride and Prejudice by Jane Austen, Moby Dick by Herman Melville, are in the public domain and can be used, adapted, and distributed. I know a lot of, I used to do some events, and there was a publishing company. They would come every year, and all she had was like just reprints of the classics. So you can take those. They're no longer under copyright. So she has the right to create and distribute those copies because they're no longer protected by copyright law. So she can make money off of copies of those works that are in public domain. Old movies, so really early films, they're in public domain because their copyrights have expired. Music, many of the classical compositions, Beethoven's Symphony No. 9 are public domain and can be performed or recorded without any copyright restrictions. So, creative works must be accessible in the public domain, must be accessible to everyone, allowing future creators to build on these works without legal restrictions. So typically, a lot of works that were published before 1924 are in the public domain, though the laws vary from country to country on what ends up in public domain. Functional elements. So it includes any aspect of the design or object that are purely utilitarian rather than artistic or creative. Couple of examples. Furniture. While the artistic design of a chair might be eligible for copyright protections, the functional elements of a chair, such as its structure and ability to hold weight, are not. So you see what I'm saying? The woodworking and the design of the chair, copywritten. The idea of I sit my butt in this chair and it holds me here, that is not copywritten. So otherwise we'd only have like one person ever making chairs. Same thing with clothing. So general designs of clothing, like functional elements, a pair of pants cannot be copyrighted. However, a unique artistic element like patterns or embellishments could be. So the design on the pants can be copywritten. The idea of pants themselves cannot. User interfaces. While specific artistic design of a user interface, like let's say the layout and the colors, can be protected, the functional elements such as the general flow, the buttons, and the inputs are not. So that gives you an example of functional elements. So there's lines between ideas and an expression that are really important for you to understand, because it's not always a clear line between idea and expression. And it's in that gray area that things get confusing. So let's say, for example, there's two writers and they are talking, and one writer says, hey, I've come up with this idea about a detective who solves crime by using advanced technology. Okay. Now, the expression, one of the other author who heard it, let's say it's Sir Arthur Conan Doyle's, and he creates the character Sherlock Holmes with very distinct personality traits, mannerisms, storylines. That is protected by copyright, though some of the stories have entered public domain, so it's kind of a moot point. Just an example. Let's say from a film genre, let's say somebody says, oh my goodness, I want to do this movie. I want to make it a space adventure, space opera, whatever. That generalized idea is not protected. However, Star Wars is a unique series with specific characters, plot lines, settings, world building. That is all protected. So I think it's very important to understand that. You see a lot of people out there, oh, such and such stole my idea. Well, an idea is a high-level concept, People could take that high-level concept and go in a billion different directions. So it's not until you go in the directions and actually outline, add characters, character names, worlds, world building, cities, towns, customs, language, mannerisms, etc., etc. Whenever you actually breathe life into that work and actually fix it, like I said, in a tangible medium, meaning you're writing it down, that's whenever you are protected. So even if you have an idea and you write down, I want to make a space adventure, a space opera, yada, 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 not protected. The overall idea of it is protected. I actually had, I went to local events and I had decided, superheroes were super popular. So I decided I was going to kind of write a superhero-esque book. And I remember talking to another author who I have bumped heads with in the past, but I was just discussing, how I was writing this book about, with the spin on superheroes and whatnot. And like the next event that I saw him at, he had this huge banner of this superhero book that he had written. And actually the marketing looked a lot like I can't think of the Disney one. Incredibles. It looked like the Incredibles. And so I walked into the event to set up and I see him all set up with this superhero and I'm like, he totally capitalized on my superhero idea. But there wasn't much I could do about it. Doesn't mean that it didn't chap my ass, but there wasn't much I could do about it because, he took the overarching idea of writing a book about superheroes and he put his own spin on it, which was actually, it was a pretty good spin. He has a disabled child, and so he wrote it from like they were superheroes, but I think they were disabled children that had superpowers, which was it was a cool concept. So it was different from what I was doing with mine. But again, overlying superhero went in two different directions. So there wasn't anything I could really do about that. So just an example of you can be upset about it. Somebody stole your good idea, but it doesn't mean that you have any sort of protection in that case.